Hi, so we have talked about the cultural environment for international business, and now we're going to move on to the next major environment for international business, which is the political and legal environment or environments. These are very important issues as we cross borders. We certainly have differences in the political structures and the legal structures that have a direct impact on international business transactions, how they're structured, and what kinds of recourse there might be if things go awry. So we're going to be discussing those issues today. We'll start out with some of the legal issues, and we'll talk about this idea of international law. Now, that's a phrase that many of you have heard. We hear it in the news quite a bit. And I think many people assume that there is some body of international law. I mean, you can even study it. You can become an international lawyer. I heard an interview with the Penn State Dickinson Law School dean the other day, and he was talking about that they've infused a lot of global content into the curriculum for all of the law students there, so that all of them are studying international law because of its importance in international business and other transactions. Well, that's all fine and good, but it's important to understand that there is a very distinct difference between domestic law and international law, so much so that, at least to me, I would make the case that, and I might lose if I'm arguing against a lawyer, but I would make the case that there is no such thing as international law. In other words, it's so different from domestic law that there isn't really an international legal system per se, or it's just, I guess, safer to say it's very different. Now, there are some core principles on which this idea of international law is built, and they're very basic. The first is sovereignty, and sovereignty refers to the recognition of a nation state as the supreme civil authority within its geographic boundaries. So as we look on the map, we see the countries on the map, and we infer that there are governments in place in those countries, and that those governments are the supreme civil authority within those geographic boundaries. Also, for those states that are recognized as sovereign, they also recognize other states as sovereign, and as part of that, there's an implicit agreement not to intervene in each other's affairs, with some exceptions that we'll get to here in a minute. But in general, the sovereign states agree to let each other manage their own affairs within their own boundaries. And then finally, equality among states, so at least in terms of legal standing, all sovereign nations have equal legal standing in these agreements, or equal sovereignty. That doesn't matter how small you are in terms of land area, population, or economy, you have equal standing as a sovereign nation with the largest, most populous, and wealthiest countries. Okay, that's sovereignty. That's one of the core principles. The second core principle is that of jurisdiction. And this is where some of those exceptions to the sovereignty rule come into play. So that the sovereign authority, the legally recognized government within each nation, has jurisdiction over the transactions that occur within its borders. It also exercises some jurisdiction at some times over the activities of its citizens. That's a little bit of an optional jurisdiction. I guess there are a lot of depends kinds of things there. It depends on what types of activities, which types of citizens, which country, but many countries exercise some type of jurisdiction over the activities of their citizens, even when they're outside the borders of the country from which they are from. And we'll talk about that more, some examples in the U.S. case here in just a minute. The big asterisk in recent years has been this third one, which is activities occurring outside borders that threaten security. So that is the exception to the agreement among sovereigns not to intervene in each other's affairs. The United States has invoked that on a number of occasions, most recently in Syria, as the United States conducts various airstrikes and things there. And also we've seen that, and also continuing in Iraq, and we've seen it in a number of different places, Afghanistan certainly. And the United States is not necessarily alone in this, although, again, has been most active in that in recent years. So the rationale is that there are security threats that mandate intervention and supersede the idea of sovereignty and that idea of non-intervention. So, all right. Well, what about this jurisdiction across international borders for citizens outside of the home country? That's referred to as extraterritoriality, so a fancy legal sounding word, where governments take some interest and some jurisdiction over the activities of their citizens in other countries. And an example from the U.S. perspective is the Foreign Corrupt Practices Act. So let's talk about that a little bit. Foreign Corrupt Practices Act was initially passed in 1977. It has had several revisions over the years, including 1988, a major revision with the Trade Act, and in 1997 it became adopted by the entire Organization for Economic Cooperation and Development, many of the other wealthy countries. What is it exactly? Well, the Foreign Corrupt Practices Act is an anti-bribery measure. It prohibits payments to government officials for the purpose of either obtaining new business or retaining current business. Okay, now it's actually a fairly narrow definition there. So notice that it's payments to government officials, and it is for obtaining or retaining business with the government. Okay, now there's another category of payments that we might refer to as bribes, which are not covered by the Foreign Corrupt Practices Act, and these are known as facilitating payments. So what is an example of a facilitating payment? Well, a facilitating payment is, well, first a definition. Facilitating payment is a payment made to some representative of the government in some capacity in order to secure certain services that would be normally expected to be part of doing business. So let me, and it's better to explain it with an example. Let's say that you've been given the responsibility by your company to go to, we'll say, an unnamed Latin American country, and you are to manage the construction and operation of a new manufacturing facility in this Latin American country. As part of that process, once that facility has been constructed, you know that you're going to need a reliable supply of electrical power in order to keep operating that facility according to plan. And in this particular country, let's assume that having a reliable source of power is somewhat questionable, that sometimes the power is there, sometimes it is not. Now that begs the question as to why you would select that particular country or that particular site for the factory. But let's assume that this was all part of the decision process, and your company was confident that that problem could be worked through. Hold on just a second. Okay, slight interruption. Let's go back. Okay, so let's say that to manage this situation, you decide to go to the manager of the state-owned utility company, the power company. This is a government employee, and you make it clear to that employee that it's very important to your facility, which is bringing a lot of jobs to the area and everything, to have a continuous supply of electrical power. And if there are any interruptions or brownout type situations on the horizon, you want to be sure that you are at the top of the priority list. And you might not only be very kind to that official, but you might have lots of samples of your company's merchandise. You might invite that official to a company dinner, or you might go golfing with that official, or even beyond that, you may give some very nice gifts to that official and or his or her family. Maybe even invite them on an all expenses paid trip to your corporate headquarters and maybe with a stopover at Disneyland or something. There are all kinds of possibilities you might explore there to make sure that you have the best possible relationship with that manager and that you secure the consistent supply of electricity to your plant. All right, well, that sounds like bribery in a lot of contexts, but according to the Foreign Corrupt Practices Act, those kinds of payments, even if it was a direct cash payment to an individual who might very well be a government employee or a government official, in that case would not be against this act because it's a facilitating payment. It's just part of the expense of getting electricity for your plant. Other services like mail delivery or internet services, other kinds of telecommunications, other things that might typically be provided by the government and that are necessary for doing business, making those kinds of payments to secure an extra level of service is not against the law. All right, well, on the other side, an example where it might be against the law, let's say that you are trying to get a government contract to provide construction services to help build a new highway or something, and you're bidding on this contract. They put forth I'm losing my mind here. a proposal, a solicitation for proposals, and you put forth a bid. It would be illegal in that instance to sweeten the pot with some type of direct or even indirect payment. So the trips to Disneyland are out. In that situation, the cash payments are certainly out. Anything, hiring the brother-in-law of the government official that's making the decision as a consultant on the project, that's out. So anything that is designed to provide some type of influence for that government official to decide in your favor on a government project that is obtaining or retaining business is illegal. But the facilitation of your normal business and being able to get government services to support that, that's a different category of things. Okay, so hopefully I've made that clear. Now this is, the United States government takes this very seriously and has prosecuted this on a regular basis when these kinds of things come out. The penalties and fines are pretty severe. Can be up to $2 million for the company, up to $100,000 for individuals that are involved, and the company is not allowed to pay that fine on behalf of the individual. You are held personally liable for that. And there's prison time that can be as part of that as well, up to 5 years in prison. So it's not something that an American citizen wants to experiment with in any way. It's a very high risk, high cost kind of activity. So there are a whole host of questions to explore here about bribery and why it is something that we should be concerned about. Clearly, bribery skews the playing field for people. It distorts the market. It does not. It relies on information being obscured and not transparent. It benefits certain people to the detriment of others, and generally taxpayers, for example, in the country in which the bribes are going on, are the ones that are not benefiting, that are being hurt by the practice, and the government officials are benefiting. So there are all kinds of problems, moral problems, with the issue of bribery, and it distorts the marketplace, and is a practice that the U.S. government has wanted to eliminate, both within the United States and for American companies operating overseas. Now, it doesn't work if the U.S. is the only country doing it, so that's why it was so important to get the OECD countries to agree. Many others have also agreed since then. So the more countries that take this same stance and have these same kinds of laws, then the more power is behind the anti-bribery movement in general. So there has been some positive movement in terms of reducing bribery in these fairly limited situations. But you can think of all kinds of situations where, in some countries, bribery is an accepted part of the business climate, and any kind of dealings with the government usually involve some type of bribery as part of the picture. And that's not necessarily to the benefit of the country in which that is occurring. And there are many countries that have tried to limit the corruption that's going on. For a business person, it's often very difficult to navigate through that, to know when that would be acceptable, when it would be unacceptable, when is it moral, when is it immoral, when is it just adapting to the culture, and when is it breaking the law. Those are difficult questions, and you have to think deeply through these issues and decide in advance what kinds of approaches you are comfortable with and are the right approaches to take from your own personal morality, from your company position, and from a legal position. And those are not necessarily all the same thing. You'll get conflicts between each of those. Your personal morality may contradict your company position and or the legal position, and you may need to sort through those things. So this is something to be taken very seriously and to be very thoughtful about. And in general, my motto is that you can't lose by doing the right thing. In the long run, doing what you feel is the morally correct thing is going to be beneficial to both you personally and to the company and to the others that are involved. Doesn't get you out of tricky situations, and doesn't mean that you would never engage in any kind of bribery. There's certainly lots of situations where that might actually be morally acceptable, again, in terms of facilitation. In fact, it might be immoral to not engage in a facilitating payment under certain circumstances. But again, circumstances vary, and so you have to take each situation on its own merits. Think about it. Think about who is benefiting, who is being hurt. Is this a cost of doing business? Maybe the official that's in charge of this gets paid hardly any salary, and it's like a waiter at a restaurant, where if you don't tip, they don't get paid very much, and so that's part of their compensation. It may feel uncomfortable to you, but from a moral perspective, there could be an argument made in favor of facilitating payments. There's never a good moral argument in favor of the types of bribery that are outlawed, though, by the Foreign Corrupt Practices Act. Anyway, so that's a good example of extraterritoriality, and one of those legal issues that comes into play in international business quite a bit. Okay, let's look at some types of domestic legal systems, because one of the things we want to do in this comparative environment is to understand how domestic legal systems differ across national boundaries. So, because without a formal international legal structure where everything comes under some umbrella, with jurisdiction being country by country, the international business person has to be aware of the country-specific regulations that apply to the transactions that you're engaging in that particular area. So it's beneficial to understand some general types of domestic legal systems and some more specific legal issues dealing with each country that you're involved with. But in terms of just general types of legal systems, there are three. There is the common law system, and this is based on the principle of precedent. So in the United States, we use a common law system, and in fact, this traces back to Great Britain. It's actually part of English law. English common law is where it developed. And so the court system of England and then Great Britain and then all of the former colonies of Great Britain, any country that has had a strong influence or an origin as part of that British Empire is likely to be a common law country. The United States, with strong connections to Great Britain then, is a common law country. Principles of precedent are very important, so court cases are significant. the courts have power to impact legislation. Legislators may pass laws, but it's up to courts to interpret them and to make rulings on those laws as cases come to bear, and those rulings supersede the legislative aspect. And for this reason, we tend to see very detailed contracts being used in countries that have common law systems, or at least somewhat more detailed. And there are other factors other than just whether it's common law or not. But we're very legalistic in the United States, and part of that traces back to the idea that we are a common law country and the courts have power to interpret the laws, and therefore you want a very solid contract that specifies every possible situation so that if it does end up in the court, there is very little room for interpretation, that things are clearly specified, and the contract can be enforced as it is written. You don't want to leave it open-ended. So detailed contracts become important in business agreements in that type of a system. Now, in contrast to that is the civil law system, and this is typical among continental Europe and any of those former colonies of continental Europe, so France, Spain, Germany, Netherlands, Portugal. All of those countries have a civil law system, and then their former colonial or former colonies throughout Latin America, Africa, Asia typically follow that civil law system as well. Japan has no colonial history of it has done some colonizing, kind of, but it hasn't been colonized. Japan has a civil law system as well. Well, what is civil law? It's based on a detailed legal code. So here, rather than the courts taking precedence and previous cases being very important, it is the law itself that is very specific, and the courts have a secondary role. They don't have the power of interpretation. You certainly do have courts. There are rulings by judges, but the law carries more weight. The legislation itself carries more weight than any kind of legal interpretation of that law. The courts are just there to enforce the law and carry that out and make rulings, when necessary, but they don't have the same weight that they would have in a common law system. Therefore, contracts are somewhat less important. Again, it's not that they're unimportant, and it varies by country, but in general, in civil law countries, contracts will be more open-ended because the law is more specific and there's less room for interpretation. There are some cultural things that go into that as well, but if you're doing business in Japan, for example, it would be less common to have an extremely detailed contract, and Japanese companies and business people might be more comfortable operating on the basis of a personal relationship without any kind of written contract at all. So again, that can vary, but there is much less emphasis on the legal documents that would be involved in the detail that's contained in those documents. Well, I said there are three types of legal systems. So what is the third type? It's common law, civil law, and there is theocratic law. So we see this in some Islamic countries where the Quran becomes a legal document, where the religious structure, the religious leaders are actually the enforcers and interpreters of the law, and so they become part of the legal system. And so the religious aspects and the legal aspects are closely intertwined. And like I said, religious leaders are in charge of interpreting and enforcing and implementing the laws and run the court systems as they exist. Again, there are variations in the degree to which theocratic law is enforced or relied upon. There are certainly countries that have a majority of Muslims in their population that do not operate on theocratic law, but some countries do rely on it very heavily. All right, I want to focus on another issue here, which is a significant legal issue as we cross borders, and that is intellectual property rights. So again, this is another area where there is no global law on intellectual property rights. There is no international court that enforces property rights or intellectual property rights at all for that matter. Those things are all done country by country, and the laws vary widely from one country to another. Enforcement is often very uneven, in some cases almost non-existent. China has a reputation for being a lax enforcer of intellectual property right rules, so trademarks, counterfeiting of products, copying of designs, all of those things are quite common in China, and at various times the government has tried to make strides to enforce some level of intellectual property rights, often in response to pressure from the United States or other Western countries. It's still quite a bit of a problem. There are a lot of knockoff products, a lot of misuse of brands, misuse of intellectual capital that goes on in China still. Now, that's not a problem that is exclusive to China by any means. You certainly have that problem in the United States itself and other countries, but intellectual property rights are enforced much more carefully in the United States, and there's just a higher level of respect for that. In some countries there is no tradition of that and no legal structure really that has been relied upon to enforce that. So that's just something to keep in mind as you're crossing borders. Do not expect that your intellectual property rights will be guaranteed or enforced or protected. You may very well be exposed. I was at a conference a while ago with some representatives of a Pennsylvania company that makes packaging equipment, this packaging equipment is in high demand in China. Of course, with all the manufacturing that goes on in China, they need to package the products that they have. So these machines do the wrapping and the packing of products to get them ready for market. Well, they're very complicated machines, and they have lots of capabilities. This company saw China as an excellent market for their machines and aggressively went into the Chinese market. They established a foothold very quickly. Their machines were well accepted. They were going around to trade shows to demonstrate the machines and to sell their product to other businesses. And after a while, it didn't take very long, within about a year, as they went to new trade shows, they discovered that there would be other companies, Chinese companies, several booths down from them at the trade show, that were demonstrating a nearly identical packaging machine to their own. So clearly these companies had reverse engineered the U.S. company's design and had just been copying it. Well, needless to say, they weren't very happy about that. They tried to pursue some options in the Chinese courts to enforce that or to get that to stop, and they quickly realized that was going to take a very long time, be very expensive, and that there was a very good chance that in the end nothing would happen anyway. So they abandoned that route. There's no recourse in U.S. courts. There's nothing they could do in U.S. courts to protect their property rights in China. So they decided that strategically their only option was to do what they'd been doing anyway, which was continue to innovate and to stay ahead of the copycat products and to come out with new features and better quality merchandise and stay ahead of the curve in terms of those fast followers. So that's what they've tried to do, and they continue to be successful, but it's still very uncomfortable for U.S. businesses to operate in those kinds of environments where we expect to have our intellectual property protected, and it may not be. So that's something to think about when going into those markets. And sometimes you don't even have to enter those markets, and your intellectual property will be copied, whether you like it or not, whether you're there or not. All right, let's shift away from the legal issues and now talk about the political issues. A very simple framework here of political systems going from democracy, where power is distributed among many, to totalitarianism, where power is concentrated among a few. So politics, as we learned from Mandelbaum and as we know generally, politics is synonymous with power. Politics is the process through which power is allocated and well, I guess that's put a period there. Politics is the power through which power is allocated or distributed, and different individuals and groups might, within the political system, try to gain more power. Power, as Mandelbaum says, is a zero-sum game, and therefore it's often contentious and certainly inefficient, often full of some irrationality, and can be very frustrating, although there is a rationality behind it. So it depends on your perspective, I guess. But anyway, political systems are designed to allocate that power and to manage that power allocation. Democratic tries to handle that process by encouraging transparency and distributing the power and having systems of checks and balances so that power can't be consolidated. Whereas totalitarianism, the whole goal is to consolidate power, and usually to obfuscate that and to pursue mechanisms in which that power can be continued in the control of just a few individuals. Okay. Within democracy, there are a number of different mechanisms, and it's important to recognize some of those differences. The Greeks, when they came up with this concept of democracy, were envisioning a true democracy, although it was limited to just males and those who had citizenship, which was a pretty high bar to reach, and I think it included property ownership and some other things. So it really wasn't everybody that was represented, but the idea of democracy is that everybody is represented, so that every person that meets certain minimum criteria. In our day and age, of course, age is really about the only one. Perhaps mental capacity and or criminal record are the other things that could come into play. But essentially everyone over a voting age has some say into the democratic process. And in a true democracy, the system would be structured such that every political decision would be made on the basis of one person, one vote. So anybody could bring an issue to the table, and everyone would have the opportunity to debate that issue, and everyone would have the opportunity to vote on that issue, and it would be a majority rule situation for each issue that was brought forward. So that would be true democracy. It's a very cumbersome system and does not exist on a large scale within a country. It would be very difficult in a large country or even in a small country to institute true democracy, and potentially dangerous because you have this effect of tyranny of the majority, which that majority could go unchecked and could become a totalitarian situation, despite the fact that it's based on the most democratic of principles. So there are some downsides there. So we don't see that. So what do we see? Well, we see representative democracy and two major forms of representative democracy: a presidential system similar to the United States. Well, the United States is a presidential system. Some countries have that kind of a system, usually with a limited number of political parties. Of course, we have two here. There might be more than that in some other countries. In a parliamentary system, though, there tends to be a much larger number of political parties. So there might be 5 to 6 major parties and several minor parties. It could be a dozen or more total parties represented in the parliament, and there are various nuances then that are different. Whereas in the United States we have very regular elections every 2 years, every 4 years, every 6 years, depending on what types of representatives we are electing. In a parliamentary system, in addition to some regularly scheduled elections, there might be, at any time, there could be a no confidence vote in the current administration, and there might be new elections that are called. Also, parliamentary systems depend on coalitions, usually, of different parties, since there's so many fragmented parties. Usually it takes two or more parties to get together to get a majority, and those parties have to compromise and hang together against the other parties that are out of the coalition. And if the coalition falls apart, then there are going to be new elections and a change in the government. So the system is a little bit more fluid in a parliamentary structure than it is in a presidential structure. All right, populist democracy is another idea just to explore. I guess our political structures with the flow of information and reliance on mass media. Politicians tend to like to play to populist notions. Of course, they depend on getting the most support that they can to get elected, and therefore it's difficult to take a stance that is against the populist views, and those views can be influenced in different ways. So I don't want to take a lot of time to go on. I know we have some other issues to cover, but it's just something to think about in the current political climate, not just in the United States but in other countries. Just the role of populism, what role that plays. But it's not a political science class, so we won't go into that too much right now. Totalitarianism on the other side of the coin, so the concentration of power. Typically we've seen a few different structures. We've seen communism that concentrates power, ironically, because the notion is to allocate resources more equally, but power still gets concentrated clearly in communism. We have theocracy, which again, may have lofty moral ideas and a notion of helping people to achieve certain objectives of upstanding behavior and everything, but it still concentrates power among a few, and in this case, religious authorities. And then we have secular dictatorship, in which it's just kind of the old-fashioned strongman government where somebody takes control and has themselves elected president for life and that kind of thing. It's not necessarily ideological, it's more just a political process that results in one winner. Okay, so those are the things that we see. We still see some examples of each of those. Communism certainly has been waning, and theocracy, I guess, kind of holding steady. Secular dictatorships still have plenty of examples. But democracy has really made big inroads around the world, and that has a lot of implications. And as we talked about with globalization, democracy and free markets go together, and the more democracy we have, the more free markets, and vice versa. The more free markets, the more democratic countries tend to be. So there has been a Washington consensus, so it's often referred to, which is liberal economic policies, meaning free trade, not liberal in a political sense, but open policies, encouraging free market activity and more open borders, free movement of capital, free movement of goods, not as much on the free movement of people, but that whole notion has been adopted by many governments, and along with that, democratic structures for the government as well. So that's become much more commonplace in the world. Okay, it's important to remember that there are lots of different levels of political organization. We often default to the country level, or what we would call in the United States the federal level, but federal government is just one layer of all of the government that we deal with. In the United States, we have federal government, we have state governments, we have municipal governments. All of those have different structures, different processes, different laws, different regulations that have to be paid attention to. And when you're in an international business transaction, then you have on the other side, on another nation's side, you have the same thing. So this is just to point out that you have a lot of different levels to consider when you are doing business in another country. You also have to take into account the federal or national structure of the government, the provincial or state level, and the municipal level. when you are dealing across borders. There are multiple government entities to keep in mind. In addition to those government entities are some regional groupings. We're familiar with NAFTA here in North America, a trade treaty, European Union, another treaty-based organization in Europe, Association for Southeast Asian Nations. There are many of these cooperative groups of nations in which trade barriers have been reduced or eliminated, and that there is some regional suprastructure that has been put in place. Functional groupings, things like OPEC, where countries cooperate to influence the market for oil, or the OECD, I mentioned that earlier. There are these more purpose-based organizations that could be a military organization such as NATO, a military treaty. But these groupings of countries that cooperate for certain purposes and reasons and have certain agendas can also influence the political process. And then finally, we have all kinds of international organizations which often don't have a lot of teeth behind them, although some do. World Trade Organization actually has enforcement powers and is the closest thing we have to some type of a world government body, at least when it applies to trade. The United Nations tends to not be able to implement things very effectively or to have much power of enforcement, although they do have a lot of attention on the world stage at different times and for different issues. The International Monetary Fund is another one of those multinational organizations. Sometimes comes under a lot of criticism, but also has been very key in stabilizing countries that are in financial crisis, and certainly has a role to play in the global economic system, but is tied into the political processes as well. Comes under a lot of criticism. So it's a very complex political and legal world out there, and unfortunately, in a 1-hour lecture, I can't solve all those issues for you, but just bring some. I hope to just bring some awareness to some of the complexities that I'm sure many of you have already dealt with and continue to deal with on a regular basis, and others may be preparing to deal with in the future. All right, I want to finish up then by looking at the interaction between governments and multinational enterprises. So this is a political and a legal interaction, and there are interests. We're going to look at it mainly from a political perspective. There's certainly interests on each side that sometimes are in conflict, not always. But we're going to break it down by the interests of governments and the interests of multinationals, and then see how that interaction often is affected. So let's look at the interests or concerns of host governments first, that are inviting foreign corporations in to operate within their country or allowing it to happen. What are they concerned about? Well, they're concerned about ownership and control of assets within the country, within the host country. They would like to see that decisions that are made by these foreign owners, the multinational enterprises, coincide with the interests of the government and the citizens within the country in which they're operating. There's worry that those interests are not aligned, or at times might not be aligned. And so governments take certain measures to try to align those interests by introducing regulations and laws that influence multinational behavior or make multinational participation in their economy conditional on certain things. One thing that is common is our local ownership provisions, so that a country may require that foreign companies have some type of a joint venture agreement to come into their country, that they can't have wholly owned subsidiaries there, that they have to have some local ownership there as well, and that is to get the local perspective into the mix. They might require the use of local management. Rather than having all expatriate employees, they might require that a certain percentage of the employees, and certainly of the management employees, it's not just the workers or laborers, but also management who are making the decisions, need to have local representation as well. This could be instituted through legislation. And there might be certain other restrictions on managerial freedom, things that the government says you can or can't do. Sometimes it's certain types of businesses that are not allowed to be controlled. In the United States, we have these kinds of things, and they flare up every once in a while. A few years ago, you may remember that a Middle Eastern company, and now I can't remember which country they were from. I've forgotten now, but wanted to buy a U.S. port and be able to operate that U.S. port. And government stepped in and said, no, unfortunately, we're not going to allow that to be foreign-owned, or at least not owned by a company from a Middle Eastern country. I think it was just a blanket no foreign ownership, though, because of the strategic importance of a port and of the security concerns that come into play. In today's environment, that's always an issue. So there could be all kinds of restrictions that help to protect the interests of the host country. All right, what else are host countries interested in? They want to have some influence over the financial flows and the balance of payments that result from the financial transactions. So a foreign company coming in may bring some capital with it, and that may be welcomed. An inflow of capital may be a good thing, but then what happens to the profits afterwards? Are they going all out of the country, or are they going to be reinvested in the country? There's sensitivity by host governments to maintain some control over that flow of profits and over the flow of capital in and out of the country for various reasons and for purposes of balance of payments. We'll talk about balance of payments more when we talk about foreign currency transactions in a week or two. So what are some of the rules here? Well, profit repatriation restrictions, so limiting the ability of companies to take profits out of the country. Instituting trade barriers to control the flow of trade and, again, try to influence that balance of payments in a way that's beneficial to the host government. And certain local content regulations, so that maybe products that are sold in that country must have some local content and can't be entirely imported, for example. Okay, other concerns, labor. So the protection of labor interests is a concern of many host governments. Some are less concerned about this, others are more concerned about it. What are some labor protections that are common? Well, in the United States we have a minimum wage, many other countries have that. Certain wage controls, you might not think about it, but sometimes there are maximum wages that are instituted for various reasons within countries and in different kinds of jobs or industries. And then the involvement of union. Are unions allowed or not allowed? Under what conditions? Some countries are very union friendly. Germany, for example, unions are very influential and prevalent, and in fact there's a law in Germany that unions or workers must have representation on the board of directors of companies. In other words, I'm saying it wrong. Companies must allow worker representation on the board. So that's a pretty strong commitment to labor protection and to unions. In other countries, China, for example, allows labor unions, but only officially recognized ones, and to my knowledge, there's only one officially recognized union in China, and so it's basically a government-run union that doesn't have a lot of power. It's not very significant. Now, workers can take it upon themselves outside of the organization of a union to push for certain changes in working conditions and wages and all of those kinds of things. We've seen demonstrations in China by workers, whether they are officially unionized or not, doesn't necessarily dictate whether or not they can demonstrate for those kinds of things. All right, technology and technology transfer are concerns of host governments. Those countries that have a lot of advanced technology often want to protect it, especially if there's a security interest there, especially if it has military application. Other countries that would like to develop more advanced technology and don't currently have it might require multinationals to incorporate technologies or technology development into their country. So things like technology review boards to protect the technology, but on the other side of it, and restrictions on the use of that technology, but also incentives or requirements for certain types of R&D activities to be done within a host country as a condition of multinational involvement in that country. So you can go on both sides, protecting technology and encouraging the transfer. Natural resource protection is another sensitive issue for governments. They don't want foreign companies to come in and misuse natural resources in most cases. They also want to extract value from those natural resources for the benefit of the citizens and the benefit of the government. So sometimes they go so far as to nationalize those resources. Mexico has a nationalized oil industry. Actually, many countries have a nationalized oil industry. Mexico is, in fact, in the process of changing this. They are opening up their oil industry to competition and to private interests. But for decades, Pemex has been the national oil company of Mexico, and there has been no competition from private companies allowed. There are also formation of cartels like OPEC. We talked about that before. Taxes and royalties are very common on natural resources, so they are a source of revenue for host governments. There's some sensitivity towards this idea of neo-imperialism, that there is some connection between multinationals and their home governments, their headquarters countries, that will mirror some of the imperialist activities of past centuries. So to counter that, sometimes there's political pressure either brought to bear by MNEs towards host governments, or actually that's the concern. And another concern is destruction of indigenous culture. So certain countries are very sensitive to these things and may not be friendly to multinationals that are coming in to try to protect against these things. All right, the other side of it. What are the concerns of multinationals? Well, they're pretty straightforward. Multinationals want definitely currency convertibility. They're not likely to operate in your country if you don't have a convertible currency. Without a convertible currency, it's very hard to do business, and there's very little incentive to operate in that country. There's no way to take profits out. There's no way to really make it work. Now, there have been exceptions to that. Some companies have gone into countries before currency convertibility has happened there, and that's in order to establish a market position and hope that in the future that will change. But and it's actually much less of an issue now because currencies are mostly convertible in most countries, so it's less of a concern. Multinationals don't want to have restrictions on capital flow. We saw on the previous list that a lot of host nations want to do some restrictions on that. The more restrictive they are with that, the less interested multinationals will be in the country. Tax policy is a big issue. Boy, we're seeing that a lot in the United States with these corporate inversions and creating these tax structures and ownership structures that shift tax burdens in different directions and lower tax burdens by shifting jurisdiction. Corporations, multinationals, they want to see a favorable tax policy, and they will shift resources and shift income and shift profits to those areas that have more favorable tax policies. First and foremost, I probably should have put this number one on the list, is rule of law. Multinationals want a stable legal environment. They want to know that the laws are fair and will be enforced evenly, and that they have protection under the law for their activities. And they want stability, general stability. Sometimes in the past, corporations have preferred stability to some other objectives like democracy or freedom for the people in the country, and have been criticized for that. But multinationals tend to like a more predictable environment. Organizations in general don't like uncertainty, and so they'd rather have the stability in the political, economic, and social situation in order to operate. All right, well, that concludes then. Oh, wait, I have one more slide here about the power balance. Actually, I might have a couple of them. What are the host country powers in this equation? We talked about sovereignty earlier, and at any time, because of sovereignty, host countries can nationalize businesses. They can just take over a multinational's operations. They can legally do that. Now, of course, that is a nuclear attack kind of option because that's going to be devastating to any future involvement of multinationals in their country. So host countries tend to avoid that, but there are many examples of where that has occurred in the past and continues to occasionally occur. Host countries have the power to regulate. They can dictate market structures. dictate the use of labor and use of resources, and those are very common. Most countries throughout the world engage in those activities. And then by structuring things in a way that competition is allowed, then competition itself becomes a limiting factor because multiple firms, that's why governments are often sensitive to monopoly activity. They would rather have competition encouraged because that provides an important check on the activities of multinationals. Multinationals can't get too powerful if they're competing among themselves in particular markets. So competition is often a tool that governments use to keep the power balance in check. All right, on the MNE side then, what are the powers? Number one, withdraw from their investment. They can just leave the country, or they can refuse to come in, or refuse to invest more. And they are important because they control a lot of benefits that countries seek. So we talked about technology earlier, employment, providing jobs, increases in exports, overall increase in economic activity, income, standards of living. All of these things come with MNE involvement in a country. And so it's very, there's a big trade-off. If a country doesn't want to allow MNEs to operate or makes the situation very uninviting for them, there will be economic consequences. And in general, at least in a democratic situation, and even in a non-democratic one, often the ability for political leaders to maintain their political power is couched in the satisfaction of the populace in their economic condition. So things that would damage the economic condition of the populace will also damage the power base of the leaders. So there's some overlap in interests and a desire among those political leaders to work with multinationals to try to get the benefits that come from multinational activity within the country, and also place some limitations on multinational activity so that certain other interests are protected. And of course, there still is that potential for parent state influence. That's a sensitive issue, and most countries don't want to see that. Most multinationals don't want to get involved in that much either. So that's generally a relatively rare situation. All right, that concludes then the discussion on political and legal environments for international business.